You may begin.
A very good morning to everyone present here. I'm Vijay Gupta, the coordinator at LawInternships and the moderator for today's interactive session. We have among us Advocate Pinak Mitra. Sir is an alumnus of the prestigious Calcutta's Boys School, Calcutta, and has obtained his law degree from the Hallowed Department of Law, University of Calcutta, with flying colors. Sir has appeared regularly before several courts and tribunals across the country and has established for himself a formidable reputation in the High Court at Calcutta within a very short span of time. He specializes in cases dealing with economic offenses, corporate frauds, banking matters, family and matrimonial disputes, arbitration and mediation, intellectual property disputes, cyber law, consumer disputes, medical legal cases, insolvency and bankruptcy issues. He has also represented the state of West Bengal and other statutory bodies on several occasions. Apart from his keen interest in criminal matters, he has also expertise in several constitutional cases and preventive detention matters. So, has also been involved in editing several legal journals, and presently he is the managing editor of Eastern Criminal Law, which is a widely circulated legal journal on criminal law. He has also done specialization courses in cyber law and also in intellectual property rights from the Indian Law Institute, New Delhi. We welcome you, sir.
Thank you.
Today, sir will be discussing about how to draft and file a bail petition. I request participants to keep their videos on and mics on mute. If anyone has any queries or questions, you can raise your hand and we shall recognize you and unmute you, or you may write down your questions in the chat box. In the end, the floor shall also be open for any questions. Without delaying any further, let's begin the session for today. Over to you, sir.
Yes, thank you so much. I'm very pleased with Law Internship for having me over to deliver this short lecture on how to draft and file bail applications. And it has always been a pleasure for me to speak and interact with students through Law Internships on various topics. And today is another such occasion. The topic by itself is very interesting because as you heard that I am into criminal law practice, and so the concept of bail is one of the very interesting topics for especially for law students also who are aspiring to pursue their career in the field of criminal law. Now, before, as the topic suggests, that how to draft and file bail applications. So this is the topic for today. But before delving into that, I would like to give all of you an overview of the entire scenario with respect to bail. If you all have a notepad with you, you may kindly take down a few important things which I have summed it up so that it becomes easier for you to understand. But the concept of bail is, we have a few sections in CRPC which deals with the concept of bail. First is 437 of the CRPC, that is bail by magistrates. Then comes 438, which is anticipatory bail. Now, when we use the term bail, it includes normal bail applications, it should include anticipatory bail, it includes cancellation of bail, it includes statutory bail, and also it includes bail which is granted during the pendency of appeal, and that is the suspension of sentence and bail. It is not a mere 439 application that we are dealing with here. Now, coming to the breaking the entire heading bail into several aspects. So first we see bail under section 437 of the CRPC. That is when the magistrate may grant you bail. If you have a CRPC, all of you may go through it and see the importance of the section. And I can also place the section before all of you. That is 437(1), that when bail may be taken in case of non-bailable offense. When any person is accused of or suspected of the commission of any non-bailable offence is arrested or detained without warrant by any officer in charge of a police station or appears or is brought before the court other than the High Court or the Court of Sessions, he may be released on bail. But so it is other than the High Court or the Sessions Court, so it is necessarily the court of the magistrate. That is the CJM, ACJM, or in case of metropolitan areas, the Chief Metropolitan Magistrate. Then such person shall not be so released if there appear reasonable grounds for believing that he has been guilty of an offense with death or imprisonment of life. So there is an embargo on that. And second, such person shall not be released if such offense is a cognizable offense and he has been previously convicted of an offense punishable with death, imprisonment for life, or imprisonment for 7 years or more, or he had been previously convicted of 2 or more occasions of a cognizable offense punishable with so and so. Now, before reading the proviso of such this section, I would like to say that all of you are aware that cases are of two types, that is cognizable and non-cognizable. Okay. Now, and also in the CRPC categorizes offenses as bailable and non-bailable. So what is the concept of bailable and non-bailable offenses? So bailable offenses are those where automatically you're supposed to be released on bail without taking you into custody. That is the practical interpretation. Forget what the CRPC or the textbook says. So you cannot be arrested in case of a bailable offense. So they have to grant you bail. In case of a non-bailable offense, again comes this cognizable and non-cognizable part. So cognizable is where the police officer can arrest you without also a warrant, and the non-cog part of it. Now, in case of a bailable offense, whenever you appear, you are summoned in case of a bailable offense, and whenever you appear, the magistrate is duty bound to release you on bail. But in case of a non-bailable offense, the discretion lies with the courts whether to release you on bail or to prevent you from doing so. Now, so section 437 is the power which gives the magistrate, it gives the magistrate the power to release you on bail or grant you bail. Now, he has to go by these two embargoes and the provisos contained there. So these are applicable in case-to-case basis. Now coming to the segment of section 439. Now 439 of the code is again important in the sense that this gives the sessions court as well as the high court the power to grant bail when the person is in custody. This is a power which is enjoyed concurrently by both the courts. Now the question arises many times whether you will approach the sessions court or whether you will approach the high court directly. You can choose either. Obviously, we as lawyers prefer, depending on the bench, whichever is favorable, we take that call. But I always suggest people to approach the sessions court first and then come to the high court. Because in that, if you do that, there's a chance that you have a second option. For example, if you file a 439 application before the high court and it gets rejected, and you do not approach the sessions court before approaching the high court, then automatically the sessions court will not grant you bail because there is a rejection order by the high court. But at the same time, so you have one chance if you approach the high court directly. Now, if you approach the sessions court, so there's a chance that you might get bail for your client before the sessions court only. And if it is rejected, so you have a second chance, that is coming to the high court under section 439. So you have two chances basically. But if you opt to approach the high court directly, so your chance gets limited to one. So that is another aspect which people should think about and then file the bail applications. And the power is absolutely concurrent. Till now, you can approach either route. But what happens is if a high court rejects the bail application, the sessions court will never entertain the bail application because it is rejected by a high court. So this is one aspect of it. That is, and the provision is engrafted in section 439(1). Now coming to 439.2. 439.2 deals with cancellation of bail. So I'm reading out that section for you. The High Court or a Court of Sessions may direct that any person who has been released on bail under this chapter be arrested and committed him to custody. So this is per se cancellation of bail, though it doesn't say that it doesn't use the term cancellation per se, but the simple term is cancellation of bail. That is section 439.2. Now, a very interesting part here is that with respect to cancellation also, suppose, for example, High Court has granted the bail and laid down a few conditions. Now, the bail order, while the conditions are laid down, in that the High Court may specify that if he is not, so there are several conditions that he can not tamper with the witnesses, the accused should not tamper with the witnesses, he should stay within the jurisdiction of a particular police station, or he shall not leave the jurisdiction of that particular state, he should report to the investigating officer till the investigation is completed, say once a week, twice a week. These are several conditions that are imposed, and it's done on a case-to-case basis. Now, in many cases, the High Court straight away also writes in the order that in case he violates these conditions, the magistrate may be at liberty to cancel the bail. If that is written, so the magistrate, if it is violated, the state of the prosecution may approach the magistrate court, and then the magistrate may cancel the bail if that liberty is given. But in case the liberty is not given, then what happens? In such a situation, for example, the High Court is granted bail and he says that these are the conditions which the accused has to follow, but the accused is not adhering to it, then the state can approach for cancellation of the bail. Now, a very, very interesting thing which happened is that earlier it was the court which has granted the bail had the power to cancel the bail also. For example, the Sessions Court which had granted the bail had the power to cancel the bail. Similarly, the High Court which had granted the bail had the power to cancel the bail. Now, after a Supreme Court judgment in 2014 or 15, the Supreme Court laid down that, though I believe that is a flawed judgment, that the court which is granted the bail does not have the power to cancel the bail, because it then constitutes reviewing of the same order, which itself is barred under section 362 of the CRPC. So that is a judgment which casts an embargo on whether the bail can be cancelled. Bail cannot be cancelled by the court which is granting the bail. Though many are not aware of the judgment, and many high courts also do not follow that judgment. But this is a very, very important judgment which I will give you later on. So this is with respect to cancellation. Now coming to the portion of anticipatory. Anticipatory bail is again in section 438 of the CRPC. So what is anticipatory bail? I suppose you are aware of it, that when a person is apprehending arrest, an FIR has been filed, police is chasing him, or he is of the view that he is apprehending arrest, then there is a possibility that police might take him into custody. So he approaches the court for an order seeking anticipatory. That is, we also term it as pre-arrest bail. Now, here, in case of anticipatory bail, here also the power is concurrent. You can either approach the Court of Sessions or the High Court for seeking anticipatory bail. The magistrate, mind you, does not have the power to grant any accused anticipatory bail. It is only the Sessions Court or the High Court. And here the same principle applies. That is, concurrent power. It's better to approach the Sessions Court, like I said in 439. And then if it is rejected, go to the High Court. And if it is allowed, then it's good. I don't think people should directly approach the High Court, not because there is any legal bar, but as a matter of prudence, you have two chances. So why not exhaust the first chance and then go for the second? If you go to the High Court directly, if there is a rejection, then it becomes difficult, and the only option is to go to the Supreme Court. So you lose out on one chance. Now, the concept of anticipatory bail is also very interesting. Once the High Court or the Sessions Court grants you anticipatory bail, it says that so and so conditions are laid down on the factors which are laid down in the section, and which you will find it section 438 subsection 2. So these are the conditions which are also given, some of the conditions while even granting an order of bail. These are applicable to the in case of bail order as well. Now, once a person is released on anticipatory bail by the High Court, what is the next step? The next step is High Court says that you have to meet the investigating officer or appear before the trial court. So once an anticipatory bail order is passed, the accused will not be arrested, but then he has to regularize that order. What is the concept of regularizing that order? That is, he has to submit himself to the investigating agency and to the court which is in session of the entire matter. As in, the court which is dealing with the main criminal case which is pending. That is primarily the court of the Chief Judicial Magistrate before commitment. So the accused, emboldened with the order of the anticipatory bail, goes to the court of the CJM of the concerned district and he surrenders. And then the CJM is supposed to see the order of the High Court and grant him bail on giving a bond or whichever the High Court specifies, local sureties, registered sureties, bond. Or the High Court may also specify that he shall meet the investigating officer of the particular case and arresting authority, and who shall release him on bail. So the police can also execute a bond and give him that, or he can surrender himself before the court of the magistrate. The magistrate will regularize the bail and then give him bail on spot, and he has to furnish the bond. So this is the concept. He will not be taken into custody. But at the same time, even after securing the order of anticipatory bail, he has to surrender before the court of the learned magistrate and get regular bail. That is mandatory. So these are the concepts of bail as far as the ongoing process of investigation is concerned. That is section 437 mainly, 439, 439(2) for cancellation of bail, and 438 for anticipatory bail. Now, coming to another important aspect, that is statutory bail. I'm not sure whether all of you are aware of that or not. So let's go to section 167 of the CRPC. So all of you can have a look into 167 of the CRPC. That is procedure when investigation cannot be completed in 24 hours. That whenever any person is arrested and detained in custody and it appears that the investigation cannot be completed within the period of 24 hours fixed by section 57, there are grounds for believing that the accusation or information is well founded. The officer in charge of the police station or the police officer making the investigation, if he is not below the rank of the sub inspector, shall forthwith transmit to the nearest judicial magistrate a copy of so and so at the same. Now, subclause 2, subsection 2. So, what is the procedure when a person is arrested? It is incumbent duty on the police to produce him before the concerned court within 24 hours. That has to be done. And usually that is 24 hours which is given for investigation. Now, when the accused is produced before the court of the magistrate, the police usually prays for either PC or JC. That is remand, which we call it in our language. So PC is police custody and JC is judicial custody. So the police makes a prayer for interrogation, further interrogation, and prays for, say, 14 days of PC. The magistrate, depending upon the case, may give that order of detention, that is remand. So in any case, it should not exceed 15 days. That is the PC period. That is the time when the accused is kept in the police station for interrogation for a period of say 7 days or 8 days, whatever it is. And GC is when he is transferred to judicial custody. At that point of time, also the police has the power to interrogate him, but he is kept in the correctional home and not in the local police station. Now, depending on the cases, it's a statutory limit that he has to be produced before the concerned court every 14 days. So there are reasons for that. Number one, that to enable the supervision of the learned magistrate before that the police or the investigating authority is investigating the case. Second, is not doing anything to the accused. He has his rights, so he has to be produced in the court. And also in different cases, in any case, and also a time limit is set so that the police completes the investigation and the charge sheet is submitted, because they cannot keep the accused for an indefinite period as long as they want. So what the CRPC does is prescribes a time limit, which you will find in section 167 subclause 2, subsection 2. That is, read the proviso if you have the CRPC with you, that the magistrate may authorize detention of the accused person otherwise than in custody of the police beyond the period of 15 days. If he is satisfied that the adequate grounds exist for doing so, but no magistrate shall authorize detention of the accused person in custody under this paragraph for a total period exceeding. Now the thing is, the accused has to be produced every 14 days. It cannot be beyond 15 days. No matter whether he is in custody for say 3 years, then also every 14 days he has to be produced before the learned magistrate who is in session of the matter. Now, the interesting part here is, so the proviso of breaks into clause A, subclause 1 and 2. That is 90 days where the investigation relates to an offense punishable with death, imprisonment for life, or 10 years, and 60 days where investigation relates to any other offense. And on the expiry of the said period of 90 days or 60 days, as the case may be, the accused person shall be released on bail if he is prepared to and does furnish bail. And every person released on bail under this subsection shall be deemed to be so released under the provisions of chapter 33 for the purposes of that chapter. Now, the thing is, so police has a time frame of completing the investigation within, say, he is accused of committing a murder within 90 days, right? So he is, say, taken into custody on 1st January. So police is supposed to submit the charge sheet within 90 days. Say January is 31, February is 28, March is 31, 62 and 28. So it comes to 90 days, right? So on 31st March, if the police is unable to submit the charge sheet and he is in custody, and on 1st of April, if the accused person files an application for bail, then the magistrate is statutorily bound to release that accused person on bail. The magistrate does not have any right to decide whether he will or he will not, as in the case of section 437. Here he has to. So there's a difference between that section is discretionary. Here it is mandatory and incumbent on the magistrate to do so. So the application for bail in such a scenario will be under section 167 subclause 2, subsection 2 of the CRPC, and not under section 437. Now, here also a scenario arises what the police officers they do. That is, they make a prayer before the expiry of say 90 days. On the 89th day, they make a prayer before the learned magistrate for extending the time period to prevent this. And many magistrates give in to that prayer. Also, what happens is in day-to-day proceedings in the court that the accused files an application for bail on the 91st day, and the learner and the prosecution of the police files the charge sheet on the 92nd day, and the bail application is kept pending, and since the charge sheet has been filed, the magistrate rejects the bail application on this ground that the charge sheet has been filed and the bail was not decided. So the Supreme Court in several judgments has said that that is not possible. If the accused has filed an application for bail on the 91st day, even before the police has submitted the charge sheet, then he has to be released on bail because it is a statutory right. There is no scope for any discretion on the courts. Now, what happens if he does not? For example, 90 days is the period, but the accused does not file an application on the 91st day. Then, and say on the 92nd day, the charge sheet is filed. Or on the 95th day, he files the application. Then he is not entitled to this right of statutory bail. He is not, because he did not exhaust his right when the right was accrued. So it is very important that he through his lawyer does that on the 91st day itself. Many people miss out on this chance, and as a result of which they have to suffer incarceration and they are in custody. Mainly it is the fault of the lawyers who do not calculate it and keep a watch. It happens mainly because of the lawyers, because the accused is not supposed to know all his rights, and from the jail also it becomes impossible for him to file that application on the 91st day itself. So if he has a vigilant lawyer who does it on the 91st day, so automatically the accused gets benefited. Now, so this is the concept of statutory. Now let us come to section 389 of the CRPC. So what is 389 CRPC? So all these concepts which I was discussing so long was with respect to bail during the pre-investigation stage. That is, FIR has been filed, charge sheet is going on, this and that. Now 389 CRPC deals with bail at a post-conviction stage. That is, you have been tried of an offense, you are held guilty, and you have been convicted of the offense and a sentence is imposed. Say a sentence, you have committed murder and the learned sessions court has imposed life imprisonment. So when you prefer an appeal before the high court, so the appeal gets admitted, you prefer an appeal under section 374 subsection 2 of the CRPC. But what happens when this sentence is imposed by the trial court? You are immediately taken into custody. Either you are in jail and you remain there, or if you were on bail during the during the investigation stage, you are taken into custody when the sentence is imposed on you and pushed to jail. Now, when you file this appeal before the High Court, the appeal is admitted. Okay. Then you file this application under Section 389 of the CRPC, seeking suspension of sentence and release on bail during the pendency of the appeal. Because what usually happens is that our courts function at a remarkable rate and justice is very delivered very fast. So it takes, say, 10, 12 years to hear out an appeal, usually. So for that amount of time, you cannot just stay in the jail. And what if you are acquitted by the High Court? So this provision is there in the CRPC so that you can apply for bail while after your appeal has been admitted and before hearing of the appeal, so that you are out, and when the appeal is heard, and if you are convicted again, you will again be taken into custody. But there is a scope that the High Court will grant you bail during the pendency of the appeal. It may take 2 years, it may take 10 years, 15 years, whatever. So for that, this section is there. So you can have a look into this section, that is 389. That is subsection 1 says that pending any appeal by a convicted person, the appellate court may, for reasons to be recorded in writing, order that the execution of the sentence and the order appeal against be suspended, and also if he is in confinement, that he be released on bail or on his own bond, provided that the appellate court shall, before releasing on bail or his own bond, a convicted person who is convicted of an offence punishable with death or imprisonment for life or imprisonment for a term of not less than 10 years, shall give opportunity to the public prosecutor for showing cause in writing against such release. Provided further that in cases where a convicted person is released on bail, it shall be open to the public prosecutor to file an application for the cancellation of bail. So the provision of cancellation is also engrafted in this section itself. Now, subsection 2 is another section which says that the power conferred by this section on an appellate court may be exercised also by the High Court in case of an appeal by a convicted person to a court subordinate there. So what happens here? Here the thing is, suppose for example you are convicted by a court, the court of the magistrate, and you have appealed to the sessions court. So ordinarily your appeal is before the sessions court. Now you file this 389 application before the sessions court and it is rejected under subsection 1. So you have the power under subsection 2 to pray for bail before the High Court during pendency of the appeal before the sessions court. So these are the concepts with respect to bail in connection with appeal. Now coming to the other aspect, that is, we were so long dealing with the magistrate court, the sessions court, and the High Court. What happens when the bail application is rejected by the High Court? Where do we go? So automatically we have to approach the Supreme Court. Now, is there any special provision under the CRPC to go before the Supreme Court to file a bail application, like we had section 439 or in case of the High Court or the Sessions Court? So the answer is no. In case of praying for bail before the Supreme Court, there is no specific provision under the code where you can file an application under that particular section of the CRPC before the Supreme Court. What do? We file an application under Article 136 of the Constitution of India. That is, we pray for special leave to appeal. That is, all matters before the Supreme Court are filed with the special leave to appeal. That is under Article 136 of the Constitution. So if the leave is granted by the Supreme Court, only then the matter will be heard. And again, the parameters are the same. So the application has to be under Article 136 and not under Section 437 or 9, whatever. Or in case of anticipatory bail also, you have to pay for special leave to appeal. Now, the concept is that bail is, in case of custodial thing, bail is the norm and jail is an exception, which has been laid down by the Supreme Court in category of judgments, but it is not followed. It's separate. Mostly it's not followed. In case of anticipatory bail also, there is a chance if the accused will abscond after being granted anticipatory bail. So the court should not exercise that power. But it's a discretionary power. The court has to balance all aspects and then grant this. So it's an absolute discretionary power and there is no binding effect. Let me tell you, both in case of bail or anticipatory bail, there is no binding effect. So you cannot show a judgment of the Supreme Court and tell the High Court, look, in that matter, the Supreme Court has granted bail, so you're duty bound to grant bail to my client in this matter. It doesn't happen like that because, as I said, it's a discretionary power. The High Court has full discretion to grant or not grant bail. Similarly, the Sessions Court also has the discretionary power. And so does the Supreme Court obviously has it. But they are guided by certain principles. That is, bail should be the rule, jail is an exception. This is the fundamental principle. There was a very interesting case. If you all have access to SCC, you can read up. That is Sanjay Chandra versus CBI. Relates to that telecom case where he was taken into custody. This is reported in 2012. 1 SCC, page 40. Here, the argument of Ram Jethmalani is set out, where he elucidates the concept of bail. If you go through this judgment, you can get it in India Canon as well. So, if you go through this judgment, you will understand the concept of bail. That is the fundamental principles of bail, which obviously the court should follow, but unfortunately doesn't in most of the cases. So this is the brief idea of the sections and the laws which we have relating to bail. Now, regarding drafting and filing of a bail application. See, it is always prudent. See, every court across the country, the filing procedure is somewhat different in each and every court, even within the state also. There's a particular court fee and this and that. So what we do, the sections I've already told you. For filing a bail application before the magistrate, it should be under 437. Before the Sessions Court, 439. Before the High Court also 439. For filing an anticipatory bail application, it should be 438 of the code. For filing an application for cancellation of bail, it should be 439 subsection 2. And for approaching the Supreme Court, it should be an application for special leave. That is under Article 136 of the Constitution. For filing a statutory bail application, it is 167.2 of the code, under 167.2. For filing an application for suspension of sentence and bail during pendency of appeal, it should be 389. So these are the sections under which you can file these various applications. Now, a rule of prudence is that the bail application should be as brief as possible. People think that we'll go on writing pages and pages in the bail application and make a very thick petition. But I would suggest that the bail application should be crisp, to the point, and very short. And even if the accused is aware of many things, he should not specifically plead them in his petition. The reason is that bail applications hearing require a lot of impromptu, on-spot, common sense and answers. So if you disclose your defense while filing a bail application, like these are your points, and write it down in the petition, the prosecution lawyers become aware of what all points you are going to argue in the court. So he will automatically think of his counter arguments and come prepared and block those points because he has access to the case diary, which we do not have. Whatever investigation is done and whatever. So bail application same. They say that it should be heard ASAP, but it takes time. So during that time, even if there are lacunas which you have pointed out or stated in your bail application, he can easily get those lacunas blocked, plugged with the help of the police, and they can plug those things so that when the matter is eventually heard out, those your points are blocked. So that rule of prudence should be that you should have a very crisp and small bail application stating the brief prosecution story and that you are in custody for so and so days and that this is per se illegal and that you are there is no chance of absconsion, you won't tamper with the witnesses if you're released, you have a property here, you have family, children, you there is no chance of flying out of India or whatever. So this is how you should go about. You cannot disclose the loopholes in the prosecution story that you can very well do when the matter is being heard on and catch them off guard during the hearing and not plead them beforehand so that they become very defensive. So this is how you should draft and probably file the application in that manner, keeping in mind all these factors. So I think I have given all of you a brief synopsis of the thing, and now if you want to ask me anything, please.
ఇంకెవరినైనా పట్టుకునేటోళ్ళము ఎవరినో ఒకళ్ళం పట్టుకునేటోళ్ళం ముట్టుకు ఎందుకు పోగొట్టాలి.
Yes, Vijaya, anyone has any questions?
No, sir, not in the chat box. There are no questions in the chat box.
I can't hear you. Can you talk a bit loudly?
Hello, sir, you can hear me now?
Yes, yes.
Sir, there are no questions in the chat box as well.
Interns, kindly ask questions. Your next assignment will be based on the same.
Excuse me, sir.
Yes.
If you could please repeat the case name which you were saying, Sanjay Chandra versus, that would be really.
Yes, that is Sanjay Chandra versus CBI. That is 2012, Volume 1, SCC, page 40.
Thank you so much, sir.
You can also find that in India Kanun. Anyone else?
Excuse me, sir.
Yes.
Am I audible?
Yes, yes. Can you switch on your video, please?
Dipali, please switch on your video.
Does anyone have any further questions? Vijay, you may continue with the vote of thanks.
Okay. So on behalf of LawInternships, I would like to extend my heartfelt gratitude to Advocate Pinak Mitra, sir, for
I
taking out.
think Deepali Bani has sent a question, so let me answer that.
Okay. Yeah, sure, sir.
Can you just
Yeah, I'll just say the question what she was asking. Dipali was asking, while applying for the bailment, if the culprit had performed any crime, maybe robbery or rape or anything, so does the sections are only we can follow up or it differ?
I could not understand the question actually.
Dipali, could you ask her without writing it on the chat?
I think she's no longer connected.
Maybe she might be having a problem with the mic.
Excuse me, sir.
Yes.
I think, sir, this is my assumption. I think she means that does the section differ from case to case, or like the same section applies for all the bailment if we
Which
want to
section?
apply for one?
The bail, the application under which the section under which the bail application is filed.
Yes, like for robbery, is it different?
No. It
For
is the same. It's the same. So that is the section under which, for any offense, if you have to file an application before the court, that is the High Court or the Sessions Court, it has to be under section 439 of the CRPC.
Okay. Thank you, sir.
That is the section for bail.
Thank you.
Are there any further questions? You may ask, sir.
I think everyone is done, I guess.
Excuse me, sir, I have one more doubt.
Yes.
Sir, can we apply for the bailment like only once, or it can be like applied twice also?
It is not, first of all, it's not bailment. It's you
I
have to
see,
apply for
sir.
bail, number one. Number two is you can apply even after rejection. There is no embargo on that. You can apply for it as many times as you want.
Okay, sir.
But
if
for anticipatory bail, you cannot. You cannot prefer a second application for anticipatory bail before the same court.
Okay, sir.
But for bail, prefer that even after 10 days, after 15 days, you can have successive applications.
Okay, sir. Thank you.
Yes, Vijaya, please continue.
Sure, sir. So I would like to extend my heartfelt gratitude to Advocate Pinak Mitra, sir, for taking out time from his busy schedule and interacting with the young minds. It was truly an enriching session, sir, and thank you so much again for being a part of this interactive session.
Thank you, Vijay and LawInternships. I'm very grateful to all of you for having me over and being able to speak to such young people and interacting with them. The pleasure is all. Thank you so much.
Thank you,
Thank you,
sir.
sir. It was a wonderful
Thank you,
session.
sir.
Thank you so much.
Thank you, sir.
Thank you so much, sir.